In this video, we're going to look at another portion of the closing speech of Lucy Letby's defence barrister, Ben Myers. This is a continuation of the video that you can see on the screen now, Lucy Letby defence closing speech revealed. So there's a couple of things to note about this section. What immediately stands out is how well-founded this portion of the statement is, and how correct it is ultimately. And the second thing is, it really demonstrates how people can be seduced and convinced by a good story, regardless of the actual accuracy of that story. Whereas facts and sound arguments are not always as convincing. So this section of the statement, closing statement of Ben Myers, begins with the subheadline of causes and coincidences. And he begins by saying, at the heart of this case, I'm going to suggest to you, being balanced in your assessment of the case are, we say, two principal possibilities when it comes to considering what happened between June 2015 and June 2016. There is the possibility that the deaths and collapses in this case happened as a result of the medical conditions of babies being cared for at the Council Chester neonatal unit over that period, and may be combined, and we say almost definitely combined, with the condition of the unit over that period, staffing pressures, what we say is the undoubted clinical fragility of a number of these children, and failings in care on that unit. That's one possibility. So all I would say with regard to these two paragraphs is that this could be expressed more strongly and more definitively. We've already been through quite a bit of the closing statement of Nick Johnson, and he is far more definitive in what he's saying. That would be a criticism of the opening two paragraphs there from my perspective. There could be a strategic reason that Ben Myers has decided to do this. He may think, I'm defending someone who is alleged to have murdered these infants. I don't want to get too aggressive. That's not the right way to approach this. The right way to approach this is to be more gentle, considering the sensitive nature of what we're dealing with. I don't know, and I don't know. I mean, that's pure speculation, and I also don't know whether that would be the correct thing to do or not. I think it should be phrased more strongly than it is. However, I'm going to read the rest of this section without interruption. I think the rest of it is very well done and pretty strong, really. And when I've read the whole of the section, I'll try to do this in the manner of a barrister. I'm not a trained barrister or a polished performer or anything like that, but I'll do the best that I can. I will read this out to you, and then we will reflect on this initial section. So it's beginning here from this third paragraph. Then there is the possibility that that young woman who was a well-trained and apparently dedicated neonatal nurse, decided to kill children or try to kill them for reasons that are beyond comprehension, unidentified, and make, we say, no sense on the basis of what we see. And to do so, it seems, out of the blue, the very year as it happens that the unit experienced a marked increase in the number of babies it was taking and the level of care required by those babies. What a coincidence that at the point the unit began to take more babies than it could properly care for, we say, but we say that on the basis of the evidence and the conclusions you can draw. But what a coincidence that this apparently inexplicable behaviour should coincide with the very period that this hospital takes on too many babies with too high care requirements. And that is based, we say, on the evidence. We know these are fragile babies. Many of them were not particularly well. That's why they're on a neonatal unit. The succession of some people who have come here to try and persuade you they're doing brilliantly. The mind boggles. They're not doing brilliantly. That's why they're there. Some were on what's been described as the margins of survivability, the unit overstretched and understaffed. You have seen the evidence, and we will go through this because we ask you to judge what I am saying to you on the basis of the evidence. They were not properly able to care for some of these babies, and there has been, and we'll look at this, suboptimal care in babies on multiple occasions on this indictment, and there has been, and it's no good trying to brush that aside now because it doesn't fit with the ever-changing prosecution theory of guilt. That's on one hand. On the other hand, we have a young woman who, on the evidence, was dedicated and highly trained, someone who raised the alarm for children who were unwell on multiple occasions. I'll come back to that as we go through this. It's not really been pointed out, has it? It speaks volumes maybe when you consider what you are meant to be sure of to convict in this case. She wasn't on the unit at the times of the events we are looking at, and it is that alone actually, well perhaps I should say it's that in particular, which allows a presumption of guilt to flourish. There is other evidence that needs to be looked at. There are things you want to look at closely and things that call for an explanation. We know that. We know that. That's why it takes 5 days and not 5 minutes to speak to you about it. We respect the position you're in, and we respect the fact of this process, and we need to look at the evidence that there is. But the standout point does have to be this, doesn't it? For all these occasions, for all the talk of coincidence, for all that's said, not once, is there any evidence identifying what it is, as in the act or the acts, that are meant to be the harm being done. That has to be a standout point, because if we step back, and we haven't looked at this yet, one of the reasons we haven't looked at this, by the way, is because this is the first opportunity the defence have had to address you like this, ladies and gentlemen. So at this point, Ben Myers is then going to go on to talk about the unfair nature of the court case, and obviously he'd asked for the infants to be dealt with individually, and that was denied. But before we go into that further, I'll be going through that section imminently. Let's look back at what he's just said and let's reflect on that. So firstly, everything that's just been stated by Ben Myers is 100% correct. If anything, it could even be asserted more strongly. I'll go over this in a second. Most people who attended the trial were seemingly taken in by the prosecution case. We know this by the accounts of those that have been in court. It seems that virtually everyone who was in court believed that Lucy Letby was guilty. And I think there are 3 key reasons for this. Firstly, they were emotionally affected by the case, and this seriously impacted their ability to reason. We still see people commenting today, admittedly they are trivial in number, with an enormous weight of evidence and expert opinion against them due to this very reason. They just cannot emotionally let go of their position. Secondly, there were many doctors on the side of the prosecution, and we put doctors on a pedestal. Ben Myers will indeed speak about this phenomenon during his closing statement. So all the way through the trial, they're hearing what are often very dubious statements, but they're all emanating from doctors, and then they're not hearing any doctors on the defence side. In this section, it becomes clear that the defence typically presented sound information, whereas the prosecution case fluctuated between specious arguments and pure drivel. It is not difficult to imagine what difference defence experts could have made to this trial. Lucy Letby has been convicted on nonsense, which could have been counteracted. It's clear that it could have been counteracted because Myers was able to do this, doubtless, with the advice of Dr. Michael Hall. If this case had been held with Evans, Bohin, Breary and Jayram up against the wealth of expertise that Lucy has in her defence now, it would be no contest. It would be an absolute annihilation, as indeed a retrial will be, if a retrial is ever held. I'm doubtful that a retrial ever will be held for this reason. And then thirdly, people are, broadly speaking, very vulnerable to a good story. The prosecution case is a compelling narrative. The fact that it's underpinned by nonsense doesn't really matter unless you deeply understand the science, which of course most people in court do not. Most people in court, as I mentioned, don't understand the science, and so consequently the more emotionally effective narrative will usually win the day, particularly in the absence of any defence witnesses. Of course, that would be completely different today. So I think this is the reason why the more that you look at what is in the court case from the prosecution and from the defence, the prosecution is just specious nonsense, and the defence essentially points this out on many occasions, and yet there were unanimous cases in this court case, and there were many convictions, and journalists were taken in, and court watchers were taken in, and people who were observing the trial were taken in. And a lot of that is simply due to the fact that people's deductive reasoning is generally not very good. But it's also a testimony to the fact that the trial was extremely unfair, very poorly structured. The judge made decisions that I would certainly criticise, and overall it was all set up to come to an inevitable conclusion. So here is a list of what Mr. Myers has just stated, and I'm going to take you through these things one by one. So let's begin with the medical condition of the infants. Children were more vulnerable than suggested by the doctors who spoke in court. Now, already, I know that the vast majority of people who are watching this video already know that this is true, but let's just reiterate how true it is. So to just go through some of the infants, child A was born prematurely, delivered by emergency caesarean section for maternal hypertension. Mother had antiphospholipid syndrome and gestational cholestasis, multiple other chronic issues. Child C was born at 30 weeks, just a birth weight of 800 grams, problems with end-diastolic blood flow, a high risk of intrauterine demise, and many other long-term complications as well. As you see here, this infant shouldn't even have been delivered at this unit. That applies to numerous infants in this indictment. Child D became floppy at 12 minutes after birth and needed respiratory support to survive. Child G was born at 23 weeks and is massively premature, weighing just 500 grams. Child I was born at 27 weeks, again weighed under a kilogram, had intrauterine growth restriction, born in quite difficult circumstances after premature rupture of membranes, again probably shouldn't have been at the Counts of Chester. Child K was born at 25 weeks, weighed just 692 grams. Child O had a subcapsular hematoma, as did the other triplet, Child P, also had a subcapsular hematoma. And then contrast that to the way that these infants were continually presented during the court cases, that they were very stable, very stable, very well. We see that continually all the way through the evidence from the medical experts. So the second point is the condition of the unit, staffing pressures, and a lack of proficiency on the unit significantly contributed to the demise of these infants. So I've been over this many times, so I'm not going to go over this in great depth again. But the poor condition of the unit is not in doubt, considering everything we know about the sewage, the prevalence of sepsis, and so on and so forth. The Counts of Chester themselves acknowledge that there were staffing pressures and staffing shortages and probably deficiencies with skill set and certainly experience on the unit, which is reflected in a lack of proficiency on the unit. And most, if not all, medical experts that have investigated the Lucy Letby case agree that this significantly contributed to the demise of these infants. The next issue was that the unit took on more babies than it was able to adequately care for, and this contributed to the collapse of numerous infants. So we know that they were overstretched, you might say, in terms of the number of infants on the unit, but also, more importantly, they had to deal with this very difficult acuity in which there are, for example, multiple births. The percentage of multiple births was approaching 60% for the indictment infants. There are twins and there are triplets, and that immediately makes it far more complex to deal with them, given as well the complex series of needs and the complex series of conditions that these infants had. So it's very clear at this point that several of these infants should have been born elsewhere and several should never have been cared for at the Counts of Chester. So to even have one infant on a neonatal unit that shouldn't be there is far from ideal. When you're looking at multiple infants over a period of time, and some of them there concurrently, it's hardly surprising that they encounter problems given the poor condition of the unit and the staffing pressures that have already been discussed. So the next point is that there were specific medical errors and poor care that was critical in many cases. So I will just go into this briefly. So in the panel report, we have these 25 identified areas in which there were failings and problems on the unit. And it's important to note, firstly, these 25 issues are not everything that they found. There were other specific medical errors that are mentioned in the preview report and in more depth in the final reports that have been submitted to the Criminal Cases Review Commission. That's the first thing. The second thing to note is that it's not just that there was poor care for the infant. Sometimes there were multiple instances of poor care for each infant. So that obviously doesn't reflect well on the hospital and the care and management of these infants, and it's pretty much undeniable that they received a suboptimal standard of care that could reasonably be described as poor. So the next point is there is no motive for the supposed crimes of Lucy Letby. They are unfathomable and make no sense. This is really a point that is undeniable. No one contests this. No one has a motive. There is nothing about Lucy that is consistent with a serial killer. She's known to be a dedicated nurse. She's known to be a highly regarded nurse. And I've gone into this in some depth in my book, as I have, particularly with the condition of the infants, is another thing that I could go into very, very much more depth. I've gone into a lot of depth about the condition of the unit. All of these things are covered at some length in my book, but no one has come up with a motive for these crimes. The way that Lucy presents and her complete lack of any psychological deterioration indicates, for me that was an immediate red flag when I first heard about this, and it cannot be disputed that there is no motive for Lucy Letby, and indeed it isn't disputed. Again, this notion that Lucy was not on the unit during some of the alleged incidents, I could show you this, but I won't because I've shown it many times previously, but we know that Lucy was not on the unit for several of these collapses, and even some of the instances where she was on the unit, they're not particularly relevant because she was surrounded by other people, or she was just arrived, or she's just about to leave, and so forth. So for approximately 50% of the collapses, Lucy cannot possibly have done anything wrong. And yet the prosecution relied on the it's always Lucy theory of, Lucy was always present, therefore it has to be Lucy. That's why you see Ben Myers talking about coincidence, because they relied so heavily on coincidence in the prosecution case. And then finally, this notion that the supposed malignant acts of Lucy Letby are entirely hypothetical, that's completely true. That's undeniably true. There is no solid, even circumstantial evidence, let alone concrete evidence in this case. Everything that is put forward by the prosecution is hypothetical, and no one pretends otherwise. There is no attempt to, for example, measure the insulin, or say that any of the insulin was missing, or explain when Lucy accessed the insulin, and so forth. And that's supposed to be the smoking gun. All of the other supposed malignant acts are absolutely hypothetical, without doubt. So as you can see, I've been through all of those statements in this section, and they are all undeniably correct. We know they're correct now. It's not even possible to contest these statements. So then the next section of the speech is entitled here, The Defence, Circumstantial Evidence and the Presumption of Innocence. So here Ben Myers is going to critique some of the court case. Pausing there, interrupting myself for a moment, you've had a huge speech from the prosecution at the beginning of this case, which sets up the way you look at it. An hour and a half from me identifying issues, but that's fairly minimal compared to what you've been told. We go through the evidence and then a lengthy speech from the prosecution, and it's bounding to lengthy, just as mine is. But this is the first time we get to hear, really, the defence case set out, so think how long there's been for you to form a view before we ever actually set out what's said on behalf of Miss Letby. It's extraordinary, isn't it, going back to the absence of evidence of this. It isn't a case, you see, where there are 1, 2 or 3 allegations where someone could get lucky, because, let's face it, that's the subtext answer to this. It's all a bit lucky, got lucky. So, obviously, firstly here, Ben Myers is raising the fact that the prosecution case has been allowed to go on and on and on with all this speculation before he's allowed to speak himself. And he's trying to, unfortunately, we know for a fact that a member of the jury was dismissed for making comments that were heard publicly that are, to say the least, very worrying regarding the direction of thinking of the jury, well before the trial was even close to being over. And we also know that people have spoken this Daily Mail podcast and said, including Liz Hall, well, I'd basically decided she was guilty before I even heard the defence. So that just shows you the level of intellect and the level of reasoning that we're dealing with. And that's why I said to you at the beginning of this video, most people don't have particularly great deductive reasoning, and they're unaware of their own cognitive biases, and they're just not very good at thinking, for want of a better phrase. They just are not very good at reasoning things out in their own mind, and they can be easily influenced by... I've spoken about cognitive biases many times on this channel, and often in the context of advertising. Now, there's a reason you see advertisers spending vast amounts of money on advertising, and people think they're immune to this, but of course they're not. They're not immune to it, because advertisers, it's been established and developed over many decades, centuries. They know how to manipulate people. They know how to make you want to buy their things, and that includes me. And prosecutors are the same. That's been going on much longer, because advertising, certainly on television, is in its relative infancy compared to the criminal justice system. Barristers have refined their techniques over decades and centuries even, and they know how to manipulate people. That's why so many people were so manipulated, when actually, in reality, all of the solid arguments in this court case come from the defence, and yet most people walked away from it thinking that the convincing arguments came from the prosecution. And that occurred for several reasons, but one of the reasons is mentioned here by Ben Myers. The prosecution was able to batter the jury over the head with this sheer weight of evidence. What chance did Lucy have? I don't think the structure of the trial was fair, and I agree with Ben Myers in this respect. So he continues, nor does the evidence from mother of babies E and F actually, when we get to it and we'll look at it, include account of any attack or attack in progress. They keep on saying an attack in progress. Where? Where's the evidence of an attack in progress at that point? So I've mentioned that Nick Johnson used this phrase of the mother of child E caught Lucy Letby red-handed. Of course, that's not true. That's absolutely untrue. And what he's saying here about the evidence related to child E and child F is very much true. If we move on from that, as I was describing to you, it isn't a case with 1, 2 or 3 allegations where someone must have got lucky and simply got away without being caught. There are 22 counts on this indictment and about 30 events by the time the prosecution have finished in their speech, over 12 months at all times, and nothing, even though, as Dr. Jairam agreed in his evidence, from quite an early stage according to him, it was all eyes on Letby. Sometime soon after the death of baby D, we're told, all eyes on Letby. Right, all eyes on Letby, what did you see? Well, nothing. And we know how true that is, because we know what happened at the hospital now, because we've seen all the Thirlwall documents, so we know the extent to which they were focused on Lucy, almost immediately. And yet, as Ben Myers rightly points out, not only did no one see anything, but the nurses were actually prevented from giving testimony, an honest testimony in this case. When they gave their statements to the Thirlwall inquiry, which were excluded from the public process, as we know, none of them saw anything, none of them suspected anything. Many of them praised Lucy and thought highly of Lucy, and several of them expressed explicitly that they consider Lucy to be innocent still. So it's not just that no one saw anything, it goes beyond that, but absolutely what Ben Myers has said there again is completely correct. Repeatedly spiking insulin bags. How do you do that? Nipping back and forth during a busy morning, topping up the TPN with a syringe of insulin in front of everybody. It's easy to say these things, to change the theories, to keep them going, to throw ideas out to you. Easy to say it. Not once is she identified to have done one of the things that underlie what is now alleged. And so, as I mentioned previously with regard to the insulin, they never say, oh, it was this insulin that was taken at this time and it was used in this quantity from here, etc., because they can't, because there is no audit trail. There's no evidence to support that. It's entirely hypothetical, as is everything in the prosecution case. So again, this is just entirely true. So Ben Myers continues, we are well aware, as you've been directed, of the significance of what's called circumstantial evidence, putting things together when there isn't direct evidence so you can draw conclusions. A bit like we say what applies to suboptimal case in this case, you can draw conclusions on that as circumstantial evidence. But of course you can use circumstantial evidence, but 30 times when it's all eyes on her, that's evidence or the absence of it. And it's hard to disagree with that. You would think there would be something of substance. You would think there would be something of solidity, but there just isn't, which is why this has become such a hugely criticised, rightly criticised conviction. Because when you look at what was actually used to convict Lucy Letby, it's so obviously inadequate and the conviction is so obviously unsafe. One thing, ladies and gentlemen, that I took the opportunity to say on behalf of Miss Letby, we took the opportunity to say at the start of this case in that brief period when I spoke to you, was the purpose of a trial is to test a theory. That's the purpose of all of this, in fact, to test a theory. The purpose of a criminal trial. Not to come here and, as I put it, rubber stamp allegations as if it's a done deal. And you know that, and we know you know that. The whole point is to test each and every piece of the allegations, the evidence, the assumptions, the presumptions, the prejudice. We are the only people who will explain to you what there is to be said on behalf of Miss Letby. We are the only people who will stand up for her. Nobody else has that role. Nobody else is going to do that. The reason you hear from the defence at the end of the case is not, ladies and gentlemen, because this is some kind of afterthought just tagged on at the end when your minds have been made up. We ask to goodness that isn't the position. You hear from us at the end because what we have to say is so important, because we should be dealing with a presumption of innocence, not a presumption of guilt. And you haven't heard it yet, as I say, and I'm grateful now that we have the opportunity, and we are grateful for the time we've been given to address you. So as Ben Myers has done earlier, this is just him trying to say to the jury, look, you're supposed to have a presumption of innocence. You're not just supposed to make your minds up because you've heard a lot of evidence and you've heard the prosecution speaking for a long time. Unfortunately, he was fighting a losing battle for the reasons that I've mentioned previously. But he is having to here fight against the weakness of the court system, the weaknesses of this court case, the weaknesses of the way the trial was organised, the weaknesses of the judge's direction, the weaknesses of people's general standards of deductive reasoning, and the lack of evidence, lack of understanding, I should say, of the jury, while having to deal with these complex issues. So I'll read the next 3 paragraphs in their entirety before I comment. But if this is to be fair, how can that possibly be fair if minds have been closed before you even hear what's said on behalf of the defendant? How could it be? We are confident that after the work you have put in and the time out of your lives that you have put in for 8 months, these proceedings mean more to you than that. The prosecution, ladies and gentlemen, are not in any special position with this. Don't lose sight of that. Just because they bring the case and they made the speeches that they have done doesn't mean they've got it right. That's a wrong presumption. They're the prosecution. Just because they drum up the blame we are so hardwired to give out when faced with allegations like this, it doesn't make them right. And we've sat here and listened carefully, and now it's our turn. And this being a fair trial, it's Miss Letby's opportunity to have her case presented, no matter what the prosecution think or anyone does. So the reason that he has mentioned these arguments and made this argument in court is because he knows very well, and he knew this when he made the application to Judge Goss, that if the prosecution is going to stand there and take up 6-7 months, I think the prosecution case took over 6 months, if I think I'm correct in saying that, then it's relentless and the defence is given no opportunity to put its case forward. So they've been almost conditioned. In fact, I don't even know why I'm saying almost. They have been conditioned over these 6 months to see Lucy Letby's guilt. And then by comparison, the defence is given then very much an uphill task to try and defend Lucy. And that it may have been different if they'd had all these experts, but even then, I think the way the trial was structured was far from ideal, to put it mildly. But if they'd had so many experts then coming in and saying, as are available now, look, all this medical information and scientific information that prosecution has presented is absolute rubbish, then one would hope that the jury could recognise there's reasonable doubt. I think that we can't, due to the way that these trials are structured, we can't even say with complete confidence that she wouldn't have been found guilty on one count. And given that the judge gave her a full life order, that would be her still in a very, very difficult situation, obviously. It would make overturning the conviction easier, but she would still go to prison and she'd still be in prison for life, and presumably she wouldn't have been allowed parole, although maybe with one count, perhaps the judge might have sentenced differently. I don't know. But you can see the problem that Myers had and the problem that he faced when we've heard a supposed journalist, Liz Hull, and other people who observed the court process, who would consider themselves to be seasoned observers of courts. You've heard them say, I pointed to this previously, that they'd already decided that Lucy Letby was guilty before they even heard the defence case. So Ben Myers was absolutely correct in his presumption that he would have an uphill task in convincing the jury, because he knows how people think, that he's in the business of understanding the way people think and trying to influence that. So that's why he's putting these passages in there, and he's absolutely correct to do that. Unfortunately, it didn't have any impact on the reasoning of the jury, seemingly. So the next bit is the hostile and unfair prosecution. I'm sure many of you already believe the prosecution to be hostile and unfair, but let's have a look what Ben Myers had to say about it. Now, you may agree with the suggestion I'm going to make, which is that there has been it's a suggestion from the defence, a very hostile reaction from the prosecution. You heard it last week, to the mere fact that Miss Letby has dared to defend herself and disagree with them. Hold in mind how you've seen her treated, and hold in mind the address from the prosecution last week. There's something I would like to explain to you, although I'm confident and hope it needs no explaining, but you will understand, ladies and gentlemen, that anyone accused of serious crime in this country is entitled to a trial by jury, and you will assess the evidence in accordance with his lordship's directions on the law, and as you're entrusted to do. So I think most of us would agree that the prosecution was hostile with Lucy. But the important thing to note here is that the reason they're doing this, the reason that they're being so hostile, and why the prosecution statement and general conduct of the prosecution in court, the reason that is so stringent, you could describe it as, I guess melodramatic would be another way of putting it, is that they're trying to create an emotional reaction in the jury because they know this is the most effective way to convince the jury, and they just say, well, it's our job to prosecute, there you go, we've prosecuted, we've done our job. It really, the ends justify the means, whatever the ends are, it seems. So Ben Myers continues, part of that process involves testing the evidence, and that includes the defence testing prosecution evidence in cross-examination. It seems to us the prosecution in this trial have taken exception to that part of the process. I'll explain why we say that. You've watched this case for 8 months and you have plenty of experience to assess how we, the defence, have gone about our task on behalf of Ms. Letby. You have seen how we've done that. Throughout their address to you, the prosecution have gone out of their way to refer to cross-examination by the defence on serious topics, significant topics, as smoke and mirrors repeatedly, as a distraction, and even saying the questioning involved in defence cross-examination was gaslighting you. That was said on the 21st of June, that our questioning was trying to create in your minds the impression there is something seriously wrong with the hospital. It's gaslighting you, isn't it? It's doing to you what Lucy Letby was doing to her colleagues in the Countess of Chester. Oh really? That's what we've been doing for 8 months. That is unjustified and unfair. That was said before we speak to you. You may think maybe to get you to think about the defence case before we've even had the opportunity to do so. Well, you've watched the case, you can judge the merits of the questioning from the defence and the prosecution, and you can weigh up the answers you got. So you can see here Ben Myers is trying desperately to say to the jury, you have to use your brain. Don't allow your emotions. Don't allow the fact you've seen the prosecution make all these emotive statements. Don't allow that to override your brain. Unfortunately, we know how ineffective this is because people make decisions with their emotions, not their brains, much though they believe that they make decisions with their brains. Unfortunately, we know that's not the case. We know that the emotional impact of certain issues has an enormous influence on our reasoning process. We know that human beings have enormous cognitive biases anyway. When you combine the two together, this is a massive uphill task for Ben Myers. But his statement that he makes here about, so the prosecution is saying, oh, it's not true that there was something seriously wrong with the hospital. We know now that that is completely wrong. Essentially, it's nonsense. We know that there were very serious problems at that hospital because you've heard someone who far outranks anyone in this court case, in Dr. Shu Lee. You've all heard him say this hospital should have been closed down. So Ben Myers makes this comment of, well, you've watched the case, you can judge the merits of the questioning from the defence and the prosecution, and you can weigh up the answers you got. Then he goes on to say, the defence have absolute confidence that you are perfectly capable of deciding, for example, which nurses have appropriate experience and which didn't, and you can judge, and this is what the gaslighting comment related to, not by accident, we say, you can judge who has changed their accounts on discoloration and whether that matters. Because that was one of the topics it was applied to when we were accused of gaslighting you. So we know that there are enormous problems with the discoloration, and that will be discussed further later on in this closing statement. But again, this is just an entirely fair remark from Ben Myers. And then he continues, the prosecution don't like us criticising the hospital or its care, and if those comments are anything to go by, it seems they don't want you to think about that. And they certainly don't like us criticising Ravi Jairam or David Harkness for their inconsistent accounts of discoloration and their failure even to put them in their notes or inquest for the inquest statements they made at the time. We'll go back to this because we're going to look at the evidence. What a stunning omission that was for such extraordinary discoloration. Again, this is undeniable. This was discussed in cross-examination. We know there's problems with the accounts of discoloration. We know they didn't give them at the time. This cannot possibly be contested. Had we not cross-examined them about this, you wouldn't even know about it. You just have what they said in evidence, not what they didn't say in the years before they made their statements to the police when they had every opportunity to do so. Of course, this also applies to Jairam and Child K. And we say that identifying that in cross-examination isn't gaslighting, it's what you'd expect to happen in a criminal trial. It's the evidence, and evidence you now know about, and we say it is in no fair way to deal with the defence by launching attacks on the defence for what we are entitled to do, least of all with regard to pieces of evidence that you may agree go right to the heart of a central issue in this case. That's a coincidence, isn't it? That it was levelled to us on that issue. Ms. Letby was accused of gaslighting throughout, and we disagree with that, but what I'm dealing with now is the suggestion that we were doing that. We've had a lot to deal with in this case, and whether you agree with what we say at the end or not, ladies and gentlemen, our task has been to investigate what has happened in accordance with the defendant's case and to challenge the prosecution. And that process you've seen is not smoke and mirrors, and it's not gaslighting. It's called a fair trial, and we think you would expect nothing less. So I think most of what is said there is correct. It's perhaps a little bit soft on where he's saying whether you agree with this at the end or not. I feel he should be stronger in some of his statements, but again, that may be strategic. But I think that you can't deny the veracity of this statement. And what he's trying to expose here is the kind of unfair prosecution tactics that I myself have exposed in my analysis of Johnson's closing speech. It's not difficult to expose them. They're very transparently obvious. So the next section that Ben Myers goes into is related to suboptimal care at the hospital, which we've already touched upon in this video. I'm not going to go over that because I think this is a nice place to stop. Suboptimal care is a critical plank of the whole reason that Lucy Letby was wrongfully convicted. So I will discuss that the next time that we delve further into this speech. What I'm going to do now is summarise what Ben Myers has said here and examine his statements in their totality. So the central point of this section of Ben Myers' closing speech is really rather simple. The collapses and deaths can be understood through the baby's fragility, the pressures on the unit, and the failures in care, rather than through any allegation of deliberate harm. That is why the speech opens by stressing coincidence and emotional testimony in the prosecution case calling on the jury to assess the actual evidence. Because of the expert panel's reports on the infants, and much more that has been learnt about the hospital, we know that this argument is viable. Indeed, it's fundamentally correct. Myers also argues that the condition of the infants themselves was misrepresented by the prosecution and its experts. We know this is true. We know there was extreme prematurity, very low birth weight, serious obstetric complications, respiratory problems, growth restriction, and other major risks that made these babies vulnerable from the outset of their lives. That is then joined to the wider picture of the unit: staffing pressures, shortages, lack of experience, an overstretched service, and multiple births that made care even more complex than it usually would be. Several of these babies should not have been in that hospital in the first place, and this poor care on the unit is not a side issue, but part of the core explanation for what actually occurred. Myers also rightly highlights the absence of a convincing criminal case. There was no motive, no psychological collapse consistent with the prosecution's theory, and no reliable evidence placing Lucy Letby as the cause of any collapse, or even being present for many of the collapses. For roughly half of the incidents, she was either not on the unit, demonstrably not present, or not in a position to have done anything relevant to the allegations, which fatally weakens the prosecution's assertion that it's always Lucy. Alleged acts are also rightly noted to be hypothetical rather than proven. There is no solid audit trail for the insulin allegation, and the broader theory rests on speculation rather than concrete evidence. Another major theme is fairness. Myers warns the jury that the prosecution had months to shape the atmosphere of the trial before the defence was properly heard, and that this creates a real danger of people deciding the case before they have listened to both sides. Many observers were drawn in by the prosecution narrative, not because it was strong on science, but because it was emotionally powerful, medic-led, and presented with the force of authority. Against that, the defence position is that the trial structure, the judge's decisions, the length of the prosecution case, and the lack of defence experts all made it much harder for the jury to keep a true presumption of innocence in mind. That leads naturally into Myers' criticism of the prosecution's tone. The prosecution is rightly noted to be hostile. It used emotive language and attacked defence cross-examination as smoke and mirrors and gaslighting, when cross-examination was simply doing what a fair criminal trial is supposed to do, testing the evidence. Myers also highlights the problems around changing or inconsistent accounts of discoloration, and correctly asserts that these inconsistencies mattered precisely because they went to the heart of the case. So finally, let's look at the assertions that Myers made during this section of his closing statement. Firstly, his assertion that the medical condition of the infants, children, were more vulnerable than suggested by the doctors who spoke in court. Undoubtedly, that is correct. The condition of the unit, staffing pressures, and a lack of proficiency on the unit significantly contributed to the demise of these infants. That's also correct. The unit took on more babies than it was able to adequately care for, and this contributed to the collapses of numerous infants. This is correct. There is no motive for the supposed crimes of Lucy Letby. They are unfathomable and make no sense. This is correct. There are no solid allegations made with regard to the insulin cases. This is correct. Lucy was not on the unit during some, in fact many, of the alleged incidents. This is correct. The supposed malignant acts of Lucy Letby are entirely hypothetical. This is correct. And the prosecution was unduly hostile and misrepresented defence position. This is also correct. Claims the prosecution made regarding the hospital were inaccurate is furthermore correct as well. So when you look back at all of the claims that were made, so there's 11 in total, just 11 statements that constitute this portion of Ben Myers' closing speech. We see that they're all correct. And it's not me sitting here giving an opinion on that. We know from evidence that is both available at the time of the trial and that has become available since the trial, that all of these statements are undeniably correct. And no one can even possibly contradict them. These are just facts. These are just known to be the case, not open to debate. So what we've seen in the case of Lucy Letby in this portion of the trial illustrates that very succinctly, is that we've seen bad science, emotional testimony, cognitive bias, and what has been an unfair trial process trumping reason, facts, and evidence. Lucy Letby has not been convicted on the facts of the case, and not convicted on the evidence of the case, and not convicted by any kind of rational reasoning. She's been convicted by having the system pile up against her, bear down on her with its enormous weight, and use a combination of lousy medical evidence. The trial was made as emotional as possible to try and sway the jury. The trial process was very heavily weighted towards the prosecution, and this has created a phenomenon of cognitive bias in those that were present in the courtroom. And as I've mentioned previously in this video, we've heard from people who attended the trial who said, I'd already decided that Lucy was guilty before we even heard the defence, and it's only the defence that are actually bringing forth reason, facts, and evidence. This is one of the multitude of reasons why the conviction of Lucy Letby is just so chronically unsafe.